A 20-year-old woman in Kerala has alleged that she was sexually harassed by a 74-year-old prominent activist. She filed a police complaint. She isn't the only one. Another woman too has filed a police complaint against the same activist. But the activist Civic Chandran got bail in both the cases. And Kozhikode Sessions Court Judge S. Krishnakumar in his bail order said that the young woman wears dresses that are sexually provocative, and so she cannot claim that she has been sexually harassed. I am Dhanya Rajendran, and this week I will look at what it means to be a woman in India who has faced sexual violence and is looking for justice from courts. I will be speaking to prominent lawyer Karuna Nundy on this. Civic Chandran got bail on two accounts. One, the judge felt that the woman wears provocative dresses. And let's be clear, the ones in the pictures are not even the clothes that she was wearing on the day that she was allegedly harassed. Civic Chandran's lawyers simply pulled out random pictures from her Facebook account, presented it before the judge, and he nicely played along. The second reason is that the judge felt a 74-year-old man with a physical disability could not have physically held down a woman and molested her. Why are we even looking for logic? The only thing I want to tell Judge Krishnakumar is that clothes do not cause sexual violence, perpetrators do. In fact, I would like to recommend this judge and all other judicial officers who have such archaic views to check out this campaign started in 2012 by a group of women called Blank Noise. From 2012, they started collecting clothes worn by women while they were sexually harassed, abused or raped. This included skirts, dresses, salwar kameezes, saris and even school uniforms. The point of this campaign was to show that clothes don't matter. Clothes do not cause sexual harassment. And this is not the only shocking element in this case. I spoke to the defense lawyer who said that they submitted 8 photos before the court. 2 of these photos were group photos taken on the day this alleged incident took place in 2020. All the other 6 photos were taken from her Facebook account to, wait for it, to prove that she is bold and brave.
കൊടുത്ത ഫോട്ടോസിൽ 2 ഗ്രൂപ്പ് ഫോട്ടോ അന്നത്തെ ഗ്രൂപ്പ് ഫോട്ടോ ആണ്. അല്ലാതെ കൊടുത്ത ഫോട്ടോസ് ഉണ്ട്. അത് പിന്നെ ഈ കുട്ടിയും ഫേസ്ബുക്കിലിട്ട ഫോട്ടോസാണ്. അവര് വളരെ ബോൾഡും ഓപ്പൺ ഒരു ഇതായിട്ടുള്ള ഡ്രസ്സൊക്കെ ധൈര്യത്തിൽ ചെയ്യുന്ന കുട്ടിയാണെന്ന് മനസ്സിലാവുക. വായിക്കാൻ വളരെ ബോൾഡാന്ന് മനസ്സിലാവുക ആ ഡ്രസ്സ് കണ്ടാല്.
അല്ല, എങ്ങനെയാണ് ഒരു ഡ്രസ്സ് കണ്ട ഒരാള് ബോൾഡ് ആണെന്ന് മനസ്സിലാവുക? ഇന്ന് ഞാനിപ്പോ സൽവാർ കമ്മീസാണ് ഇട്ടിരിക്കുന്നത്, അപ്പൊ അത് ബോൾഡ് ആണോ അല്ലയോ?
സൽവാർ കമ്മീസല്ല, നിങ്ങളെ ശരീരത്തിന് ചേരുന്ന അനുസരിച്ചിട്ടാണല്ലോ പറയാ. അത് ഓരോരുത്തരും ഇപ്പൊ പോലീസ് ഓഫീസർ യൂണിഫോമിൽ വരുമ്പോൾ നിങ്ങൾക്ക് വ്യത്യാസം കാണോ? പിന്നെ അതിന് ടൈറ്റിലും ഇടും. അതിന്റെ ടൈറ്റിൽ ഇടുന്നുണ്ട്. ഈ ഫോട്ടോയുടെ മേലെ ടൈറ്റിലുണ്ട്. ആ ടൈറ്റിൽ ഇപ്പൊ നിങ്ങൾക്ക് പറഞ്ഞു തരുന്നില്ല. ആ ടൈറ്റിൽ കണ്ടു കഴിഞ്ഞിട്ട് ആ ഡ്രസ്സ് കൂടി കണ്ടു കഴിഞ്ഞാൽ മനസ്സിലാവും. ഡ്രസ്സ് കണ്ടാലറിയാം അവള് എന്തും ചെയ്യാൻ തയ്യാറായിട്ടുള്ള ഒരാളാണെന്ന് മനസ്സിലാവും. അത് ഇപ്പോൾ തന്നെ ഫേസ്ബുക്കിലിട്ട ഫോട്ടോസ് ഞങ്ങൾ കൊടുത്താൽ ഇങ്ങനെയുള്ള ഒരാളാണെന്ന് കാണിക്കാൻ പറ്റും. ഈ വെരി ബ്രേവ് ആൻഡ് ബോൾഡ്. അതെന്തിനാണെന്ന് പറഞ്ഞാൽ ഓൺലി ഫോർ ദ പർപ്പസ്. എന്താണെന്ന് പറഞ്ഞാൽ she preferred the complaint only after 2.5 years. ഇത്രയും ബ്രേവും ബോൾഡ് ആയിട്ടുള്ള ഒരാൾ എന്തിനാ ഇത്രയും 2.5 കൊല്ലം കാത്തു നിന്നത്? അത് മാത്രല്ല, ആ കാത്തു നിന്നൊരു കംപ്ലൈന്റ് കൊടുക്കുന്നത് അതിന് മുമ്പത്തെ ഒരു കേസിന്റെ ഫൈനൽ ഹിയറിംഗ് വരുന്നതിന്റെ തലേന്ന് വൈകുന്നേരമാണ് കൊടുക്കുന്നത്.
So according to this lawyer, a woman's decision to file a complaint perhaps a few weeks, months or even years later after the incident depends upon what clothes she normally wears. If she wears a short dress, a pair of jeans or skirt maybe, she will file the complaint immediately because she is bold and brave. But if she wears a sari or a salwar kameez like me, then she'll be scared to file a complaint. And of course, as the lawyer says, the captions on her Facebook page or Instagram also shows how bold or brave she is. But the judgment takes it one step further. The judge looks at these photographs, remember again these were not taken on the same day, and says that these are provocative dresses. So that means if on any particular day of the year a woman wears a dress which someone finds sexually provocative, then she is game to be sexually harassed on any other day of the year. There is an urgent need to sensitize our judiciary. There are too many orders in front of us that reeks of patriarchy, misogyny and sexism in courts. And I would like to tell the judge 2 questions that he could have instead asked. Why did you take these pictures from a Facebook account? This is a breach of privacy. The second question he could have asked is, These pictures have nothing to do with what happened that day. Why use them? This is not the first time that we are outraging over a judgment that is blatantly sexist and, of course, irrational and perhaps even illegal. But what can be done? What can people do? What should courts do? Should the Kerala High Court be stepping in at this point? To discuss all this, I am joined today by prominent lawyer Karuna Nundy. Karuna, thank you for speaking to me. My first question is, you read this judgment, the two judgments in fact that this judge has given. What are your thoughts on it?
This is a judgment, this is precisely the type of judgment that the Supreme Court had made very clear observations against and passed guidelines so that such judgments are not passed in the Aparna Bhatt matter of 2021. And one of the things that they had said that there must be trainings, that sensitization of judges and lawyers, that these questions must be in the exams. So when you recruit such people, the training must be mandatory, and that you must recruit people based on their approach to such questions. But in addition, and prosecutors as well as judges. But they also quoted something very interesting, which I'd like to tell you. It's the Canadian commentaries on judicial conduct. And the Supreme Court cited this with approval. They said that the wisdom required of a judge is to recognize, consciously allow for, and perhaps to question all the baggage of past attitudes and sympathies that fellow citizens are free to carry untested to the grave. You see, the point is this. The point is that when you have a judge that will take the laws that are meant to protect women and Dalits and Dalit women and interpret them in a way that is not just against women and Dalits, but anti-constitutional, then what's happening is that you are taking the attitudes and actions that lead to the violations and the crimes in the first place. And then you are reinforcing not just the attitudes, but you are bringing state power to bear to the victimhood of the complainant. And that is a major, major problem and cannot be underestimated. The high courts have administrative and jurisdiction over these sessions courts and district and sessions courts. And I think that there are two orders by this particular judge. And the first order is of the 2nd of August and the second is of the 12th of August. In two separate orders, he has said that in para 10 of the 12th August order, the judge says that the photographs produced along with the bail application by the accused would reveal that the de facto complainant herself is, and I quote, exposing to dresses which are having some sexual provocative one, right? I am told reliably that what this is referring to is photographs produced by the complainant that were not related to the matter in the sense that they weren't photographs of what she's wearing on the day, which is in itself irrelevant. That they are photographs of what she was wearing on other occasions. And that in those photographs, there are some sexually provocative one. Now, either this means she had one dress or some dresses that sometimes she'd wear a dress that this judge decided in a judgment was sexually provocative, or that, so that either there was one or some dresses. Now, not only is the point that what is the relevance of this to anything, right? The point is that there are actually explicit guidelines against exactly this in the law. And this is being violated. So the fact that you have this person who is getting the benefit of anticipatory bail, which I'm not on the result. Look, he might have gotten anticipatory bail anyway, but he cannot get anticipatory bail for this reason. The judge has also, to be clear, got the law wrong in another regard. First, he reproduces the section And anyone who reads a little bit carefully, you don't have to be a lawyer, can see this. Section 354A, sexual harassment. Section reads, physical contact and advances involving unwelcome and explicit sexual overtures or a demand or request for sexual favors. What he says here, and then in the very next para, in order to attract this section, there must be a physical contact and advances involving unwelcome and explicit sexual overtures, right? But there must be a demand or request for sexual favors. Now, it appears that what he's doing is he's reading them conjunctively instead of disjunctively. So it's not an or, he's reading it as an and, you know. So in general, there appears to be a deep, deep misunderstanding of what this gentleman's role is as a judge. Because even in the 2nd August order, which concerned the Dalit complainant, he has said that the accused is a reformer for a casteless society, and therefore that he couldn't possibly have known that the complainant was Dalit and that he would not have done such a thing. Now, I can't see how that presumption can be made, because by making that presumption, what he has taken away is he's completely hacked away at the substratum of the law, which is in the Prevention of Atrocities Act, saying that you cannot, in such a case, be given anticipatory bail in such a case. So now the thing is that by bringing this presumption in, he has taken away the Dalit woman's ability to have anticipatory bail denied to this person. So in such egregious cases, I think that very, very strong action should be taken and messages should go out. For example, in the Pushpa Ganediwal cases that were where she decided in 2 separate POCSO cases that sexually assaulting a child over the clothes does not qualify under POCSO, thereby basically making up the law, as this gentleman seems to have done. She was not, she resigned the day before her confirmation as a permanent judge of the Bombay High Court came up. And really, it was just as well, because I suspect that, I hope that she would not have been continued. Because you have not only a large number of children then being endangered, it has a knock-on effect on a large number of cases, And so this sort of thing, I think, it cannot stand. That there have to be, I think that judicial officers who make decisions in such a manner, I think immediate action should be taken to remove them from their position. At the very least, there needs to be a suspension, an evaluation to see that is there progress that can happen, and then very intensive courses, and then to see in non-judicial situations whether some major change has happened before people get put on the bench, because the consequences to people who are already extremely vulnerable and who have summoned the courage and taken the trouble and the money and the other backlash that comes when a survivor goes to court, that can't be the result of people bringing their own prejudices and their extra-constitutional and their anti-constitutional attitudes into the law.
So, Karuna, I'm sure that the bail order will be challenged, and the women's lawyers, the lawyers who represent the women, they will tell the court that the dress was not even worn on the particular day and that this comment is not acceptable. But the whole judgment has been discussed for the past 2 days. We have not seen the Kerala High Court reacting to this at all. Are you saying that the High Court has to step in now?
I am saying that the High Court really should step in on the administrative side. And it's only, I think that, I'm not sure when the news came out, but the decision is of the 12th of August. So it is fairly recent. And judiciaries don't move so fast. However, I do think that it's important, prompt action is important on the administrative side. The judicial side will, in any case, be hearing the orders against the anticipatory bail order of the sessions judge. However, on the judicial side also, I think there are a number of remarks that must be expunged. But on the administrative side, I think the action is even more important.
My final question to you, Karuna, is that one judicial officer, one judge in Kerala was criticized a lot for the judgment in the Bishop Franco rape case. Then the survivor in the Dilip case has gone to court twice saying that she wants a judge changed, a woman judge, for not being sensitive to the issue of sexual assault and the way the case has been conducted. This is the third case that we are seeing in a row where a judge is being criticized for the judgment that was given. So, two questions really. The High Court did not step in the other two cases also, and this is a third one. What more can we do? You said there are guidelines by the court on how judicial officers should behave, but we are continuously seeing this and people's faith is getting eroded in the system itself.
I mean, I'm wondering whether you could petition the court to act on its administrative side, saying that that what is being done is not enough, and to initiate action on their own, to look at what's happening. I think it's definitely worth trying, because I think that the constitutional rights of the most vulnerable people, you have Dalit women here, you have women being raped, you have, in the Bishop Franco case, you had nuns who were in a very sort of special position of vulnerability. You have women being accused of, you wear one dress at some point that goes on social media and then suddenly it's okay if you're sexually assaulted. So there's something going on, and I think it's imperative actually that action be taken. And if the High Court is not taking administrative action on its own, then it's worth a petition.
That's Karuna Nundy telling us that it is high time the Kerala High Court steps in. Let's wait and see if that actually happens. Thank you very much for joining us this week, and remember, independent media like the News Minute needs your support, so become a member of the News Minute and subscribe to our YouTube channel. Thank you.